Yes, yes, take it. From which police station? Do you have the number? Can you give us?
Yes, charge sheet number 38/25 dated 28/3/25.
Okay.
May I please, Your Lordship, Lordship, item 30,
Approach the appropriate forum.
Lordship, item 30 already charge sheet already submitted.
Do you have the number?
We do not have that information. Lordship.
Yes, Mr.
Want to withdraw, Lordship.
We don't have that information. Lordship.
You have the number?
Yes, sir.
What is the number?
Charge sheet number I have not, but the case is listed in the online and it is in the evidence space.
Mr. M. Rahman, counsel appearing for the petitioner and Mr. Petitioner by on instruction.
Yes.
Mr. Rahman, learned counsel for the that in the meanwhile. Do you have the case number?
Yes.
Final case number. What is the case number?
44. 44.
44 of what?
2025. It is
The trial case number.
POSCO. Yes. POSCO case number.
Second is the after filing of the NDPS number of the case number. In the meanwhile. Okay. Which is the next date for evidence? Any idea?
16. 16. 16/5.
Okay. Yes.
Item number 23.
Alright.
Some time may be granted here to go through the scanned copy of the case report.
Under prayer be counsel for the petitioner, Mr. Product. Matter be after 2 weeks
Yes.
on a date to be fixed.
May I please, Lordship, item number 49, Lordship, and the status report was called for on last occasion, Lordship, is not available. As per
This is from which police station?
it is from Mornoi, Lordship,
Mornoi.
Mornoi, Golpra.
Mr.
19, Lordship.
When is the time?
19,
Give us a date.
Lordship,
19.
19, Lordship,
Not on 19, make it on 21st.
21st.
It's on 21st. Okay, that was called on it to sign.
Deeply obliged.
Much I'd like to mention one criminal petition. Because it speaks on 21st on the work.
21st.
May I proceed? I'd like to mention a bail application for withdrawal for tomorrow, Lordship.
Not come against an order of framing of charge. Here is criminal petition.
When did you file
It's on last setup. Picked on 16 in the court below for evidence. We have not handy tomorrow.
15th on 5.
My father said
14th, not tomorrow, on 14th.
May I please, by best mention item number 42, my lord. 42.
Yes.
May come up next week, my lord, any date, my lord.
CD has been received. Lordship.
Are you on interim?
No, my lord, I am not taking.
Less than 19 on declare Mr. M. Hussain, counsel for the petition. CDB retained.
All right.
Effective item number 18 by law.
18.
18 by law. Here, it will be adjourned for the day by law.
May I please. Item number 34, Lordship, 34. I think case there is not received, Lordship.
Which police station?
Narayanpur, Lordship, Lakhimpur district.
Lordship, let it be on 21st.
It's on 21. 5. For the 11th of all. Yes, no problem. 30.
CD has not been received, Lordship. It's
Which
from
police station?
GRP, Lordship, Guwahati GRP. Lordship, next week,
Monday.
Monday.
Similar their lordship of 36 October.
36. This is from which police station?
September.
Same. Monday.
Monday, Wednesday.
19/5,
Wednesday.
2020. On which date you?
20.
36. Item 36.
35 and 36, vote on 19th of May, next Monday.
On 19 and Wednesday 36.
Okay.
Same PS case.
Same case case. What do you want?
Senior.
Anyway, it doesn't matter. We'll see. Let it be 19th then.
May I please, your lordship? I beg to mention item 29, my lord. POCSO matter, my lord. I think, my lord, service report is waited, my lord. 29.
CD has been received also regarding instruction, we are still awaiting. Lord. Next week, Lord, we'll take.
119, my lord. Or 20, my lord.
20.
My lord. Highly obliged. Highly obliged.
Mr. Sharma, get it on 20th, get the information.
Lordship, actually, item 38 is case number 47, not 44.
POCSO case number 47.
Case number 47.
Pending before whom? Special judge?
For production of accused.
Pending before whom?
Pending
Special
before
judge, POCSO.
Additional session judge, special judge court. Morigaon.
Special judge POCSO. Additional session judge Morigaon.
Additional session judge,
POCSO case number. Arising out of the decision.
court number 3.
Okay.
Okay.
Yes.
The matter of 2019, my last decision 15/6/2021. Is informed the police officer. The dispatch of the newsletters of the plan of it. It matter be decision 19 of 25.
19th.
May I please, your lordship? Lordship, I have mentioned for listing, my lord, new matter. Mention matter. I had filed 8/5. Kindly tomorrow, my lord. Criminal appeal.
Just find out the defect that you have filed it on 8
Equated.
tomorrow.
Deeply obliged.
If it is there is any defect, it will not be listed.
My lord.
Not be listed. Yes.
Item number 46.
46.
What is the matter? Next week, Lord. It is available. City may be retained.
What is office note?
Lordship,
POCSO
regarding-
case over.
Yes, yes. Lordship, POCSO.
Wait for a minute. Yes. Wait for it.
I'm appearing on behalf of the informant lordship in the same case.
Just a minute. What's your good name?
F.H. Laskar.
FH?
Laskar.
Have you filed wakalatnama?
Yes, lordship.
When?
About a week ago, lordship.
Pardon, Mr. BM Deka. Council appearing for the petition.
Lordship, I have allowed.
M. Alam. On behalf. Mr. P. Sharma. Also heard Mr. FH. Provided the appearance with behalf of the informant. Clear, counsel. List on 21st. Mr. Sharma, written ticket.
May I please, your lordship, I beg to, may I please, your lordship, I beg to mention for listing of regular bill, lordship.
When did you file?
I, lordship, big days, lordship, last posting of that, 2nd May. It's 2nd April, lordship. Last posting of that.
What is the order passed on second? What was the order passed on second May?
I don't know.
Case number?
Bay number 3960. 24 Lordship.
Give us the number. Number.
Number.
BA number.
Bay number 3960 Lordship 2024.
Which year?
24.
24 Lord.
Three nine six zero.
Yes.
2024.
Yes.
Yes.
No record.
Case number to believe it now.
Sharma. Case number three. Which one? Main application is the type. Okay. Friday.
Lordship.
Two.
What the petitioners have withdraw this bill.
Yes, what's your prayer?
Petitioners instructed us to withdraw this bill.
On the prayer with, Mr. Exit. Art council, very. On instruction. Praise for the case will if we can find out. With the. Response.
May I please, your lordship, I beg to mention item number 28 and 30.
Yes, item number
28 and 31. Lordship, we are filing objection today. Our objection may be called for.
28 and
31.
give it, ma'am.
Highly object.
I beg to mention for listing a bail application for withdrawal.
Oh, 12. Tomorrow.
Possible complaint.
Tomorrow.
Yeah, in this case, lordship, earlier your lordship rejected the bail application, which is second bail application. I just wonder one thing, lordship, like I insist that here in this case, that I have raised the issue that the grounds of arrest were not communicated, that your lordship will find in paragraph 8, 9, lordship, but inadvertently I could not elect the certified copy. So I will be allowed to file additional affidavit to bring on record those documents, lordship. And LTR will be called for.
Notice need to be issued also, POCSO case.
Whether lordship will grounds of arrest are not
Call
communicated.
for the record. Eligibles can prepare special case number 150. From report of blood special. Rising also. Sorry, Council, 16 of recruit, corresponding to the 16 of recruit. So notice the informant. Let's compare. It's on 19, 27. Take steps. During the course of the day, the informant.
Then I may be allowed to file the additional.
That's no right.
All right. And certainly this matter may be taken after some time. And this now also is the.
You have to call for the records on.
Folks, matter. And it is rejected by not.
Records of official case number 139. Arising of further police case number 29 of the. Corresponding to year number 53 of the 20. In bracket 36 of the 20. Number 58 will be. It's the informed best model. Same day. For further. Yes, next. Yes, Mr. Wahid.
My lord, the POCSO matter, my lord, why prosecution witnesses, my lord, has already been examined. So,
Right, please, Your Lordship. Lordship, here my case is, my lord, I have not been harnessed the ground of arrest. I have also annexed the notice case 24. Only case reference number is given. No ground. Case 24 is the notice under section 47, special prosecution number 25 of the 2025. Registration case number 186 of the corresponding to number 432 of the 29 on the concept book. Chalmar Markata. The book of Take steps on the informant. The records of it. 27, 29. And yes, Mr. Mohammed.
Section 21C NDPS. The main ground for non-compliance of my lord, section 50 IPC corresponding to section 47, 48.
Was the letter record come?
Yes, page 30 notice.
Court of special in bracket narcotics. That was case number 3 in bracket of my dog. 2022. Court of Learning. Special judge. NDPS. Concept in the morning. Along with the airport. New going out GRP. Yes. Dr. Roman C. Going out GRP is case number 87. Going on to I don't 19 list on 27.
Under section 6 of. I discussed my scan copy along with document.
Special POCSO case number 140 of 2022. Along with the records of Laluk Police Station case number 177 of 2022. Corresponding to the number 827 of 2022. Total knowledge patient has look into 19 29. Take steps on the informant. Today. It's a case number 447 of 2022. Along with the records of previous case number 34. Correspond to the clear number 159 of 2022. Report of knowledge patient. NDPS. Okay. Number 19 29. Yes.
Meet Vijay. The second bail application NDPS case. This time my only ground is that no ground of arrest was furnished to me.
No problem.
I got the certified copy of the almost entire record, Lordship. Can I place it in the house?
You have to call for the record and you will get it ready.
Lordship is keen to look into the record. Lordship. A record is already here, Lordship. In my earlier application,
It was rejected. It was rejected when
the case number is Lordship DA number 3037 of 2020.
anyway. Just
LCR is
special was indicated NDPS case number 43 of 2022. Along with the records of other PS case number 69 of 2022. From the court of law and special judge NDPS.
If Lordship, may I pray, Lordship?
Karimganj Sri Bhumi.
May I pay lordship if lordship tagged his case with the earlier bail application where LCR is there, lordship?
That's a November. It's not a new one. It's a-
Since I am only relying only on regarding lordship notice
Let
only.
us see. As on 19th. to 28. Okay.
Mr. If is agreeing in this matter, he's engaged in court number 11. I'm saying.
Just a minute.
Lordship, charge sheet has already been submitted in this case. Today, the petition is in custody around 277 days. 11 witnesses have been examined. Charge- Allegation is under section 22C of the NDPS.
What is the trial case number?
Lordship,
What is the trial case number before the London special judge? After the search sheet, what is the case number has been registered? Search sheet was already filed.
a charge sheet has already been filed.
Then what is the case number before the London special judge NDPS?
It is 257 by 2024.
Where it is, which page?
Lordship, this is the charge sheet. Lordship, kindly make it a counsel for the timing. Which is
Not required. Anyway, you will have to have the case record.
Page 276 page. Should I think of- 6 witnesses have already been examined.
Do you have any copy of the evidence of prosecution? with you?
Lordship, no evidence did not take place.
Records of NDPS case number 113/2024. Along with the records of culture case number 1257/2024. Special judge NDPS. Session judge Pachar. Very good. That's on 19. List on 27. Take back. Yes, Mr. Chaudhary.
Wait, please, your lordship. Lordship, this is a 439, lordship, this is a regular bail application, lordship, 49 days in jail custody, lordship. So far, lordship, allegation lordship will find on page 14, lordship.
Yes, get from Hatigaon. Give us a date.
Lordship, otherwise 35
On-
notice was not issued because.
19 lordship.
Let the records come next Monday. Let the talk the next Monday. Probably 19th. Total 11 case. Hatigaon case.
Yes, your lordship. The regular bail application of rent about today's 48 days. If error, my lord, number
Manikpur from Bongaigaon.
Gosaigaon, lord.
already released in lordship.
District is, this is Gosaigaon or Manikpur?
Gosaigaon.
Manikpur.
Manipul, it is Gosaigal, Manipul.
This is item number 12.
But it is written in Gosaigal, it is Gosaigal. Well, no, then.
Amjadali. Itno, Amjadali and another to Billy Amjad.
Oh, it is given different one, but
21st.
not.
Exactly. Regular petition, we got telling the three appeal orders. First order passed by district magistrate 1911-24, and the second was in below additional session justice 2025 order. Here below, while we challenged the order 1911-24 before the planet additional session just below, we challenged that while the 1911-24 exercising the power under section 146 do not corrected, attach the property, whether by violating the provisions of the CRPC provision of law. While exercising the 146 procedure, the 145 will come together. Lordship, I'd like to draw your lordship that earlier trial court order at page lot 62 first. Then I will take the final appeal order. Ultimately, without exercising discussing the matter or division regarding the illegality or error in the not discussing the provisions of law, on maintainability ground, our revision to dismiss Milord. It is true, it is admitted Milord against the interlocutory order is revision is not maintainable. But Milord, when there is regarding the defect of law, Milord, not discussing of law, Milord, the revisional court is the only court to discuss on this point, Milord. And we have also taken that specifically, Milord. And trial court in the session court also recorded that the violation of provision of CRPC. Despite this, on maintainability ground, our case was dismissed, Milord. The trial court order lordship will find at page 62 in except 12. It is order dated 1911-24. I think 11-24. The first part is found in the application very same day, Milord. Without applying the provision of 145, directly 146 attacks the property. Whereas the land that they disputed, we have purchased this land in the year of 2022, they purchased 2020. Admittedly, we are in possession. And on this point, Milord, the ethics court also on this point, the within actually tradition, this should be discussed, Milord, while issuing the proceeding under section 146 Milord. Very first thing, Milord, 146 is instead of Milord 145, 110, 146. And the MP order below, in paragraph 11, we have been directed that yes, we have been directed the revisionist was in a position to assert such an order of attachment before the learned trial court. The learned trial court, after hearing the parties, was in position to vacate the such order. And in view of the such provision of settled law, no mutual is tried against such interlocutory order, where the parties have the scope to approach against the such order before the trial court. We have been directed to approach the civil trial court again. Where if there is a application of law is not properly exercised, where before this court. There is no point, the trial court, the outlet is pending or the stays, Lottery, in the MP order lottery, page 64 can level. Page 64, the ground we have taken in the revision court, specifically ground number 3 and 6. At page 64 and 65. to C.
Heard Mr. P.K. Taken and also referring. This one. This criminal petition. filed on 05/05. Under section 5/8 PM. The case result will be known. 0602. In criminal division number 1 required by the petition. Again, the order that 14/06/2004 and 19/11/2004. Passed by the petition for the strip. In case number 56. M. Of the 54. Whereby there are additional session. But I'm a divisional. But it's not rejected. The division petition of the petition. Being criminal. Holding that the order passed by the London National Investigative District under section 146 CRPC. It is only an interlocutory order and not a final order. And according dismissed the state division petition number, criminal division number 101. Being not listen of this. Call for the eligibles can copy of the records of criminal division number 101. Sorry, additional session. That's it. Again, eligibles can copy of the records of case number 56 can be Gotcha. It's you know, it. Return and reply. Both of them. Petitioner subjects of the recommendation. Petitioner subjects get subjects of placement. Respondent number 2 by registered court on or before 14/05. Wedding is correct. List 80.
Mayor, please, your lordship. Sir, this is the petition under my lord, the Article 482 of the share distribution for party. So FIR, my lord. Page 33, my lord. The allegation is that my lord, this petition for a lordship. He is stated to be the president of an organization who had called for a Bharat fund on a particular day, my lord. That was, my lord, in protest against the delimitation process of the government, delimitation of the constituencies, my lord. But then, my lord, what had not been taken into account is that, my lord, before the actual date of the bond, my lord, this bond was withdrawn, my lord. If your lordship kindly sees, my lord, page 28, my lord.
Heard Mr. G. Chaudhary calls to declaring for the petition. Prosecuted. Appearing for the split. Why number 2 you have made a particular personal?
My lord,
It will delay the matter on. Is the informant, right?
yes, my
So in his official capacity has done that.
yes, my
Why, what is the necessity?
Well, ultimately, my lord, he becomes an informant, and my lord, even in the course of the trial, my lord, he may have some person, I don't know, my lord. So yeah, what is ambiguity, my lord, that this case, that I had.
And on going to let it call for the record also. Their case number 1364 or 2053. Yeah, number in bracket PRC number 2260 of the 2024. The people can copy of it. Arising out of Collingwood Police Station case number 486 of the 2053. Along with the record. From the court of London. Additional judicial magistrate. Stay for me. Collingwood. Done over by part of the petitioner is correct. So we see the text of the next statement, but it's about the but no. Petitioner shall take steps subsequently to the informed respondent of the quick list of
Look, he then the father proceeding. Nothing will happen. 17, my lord. Now, kindly see, my lord, this man is a liver transplant by the patient, my lord. I have assisted medical reports also, my lord.
at this stage informed that you have filed a criminal petition. That's all.
My lord, if your lordship kindly please, my lord, if your lordship kindly give me some time, my lord. Why I am, my lord, telling it that, my lord? After, my lord, all along, my lord, Bhajanlal's case was followed, my lord, where, my lord, the only requirement was,
Consider on third,
whether, my lord,
Mr. Chaudhary, not at this stage.
my lord, 17 is his death, my lord. If my lord, in this ill age, at his ill stage, my lord. Liver transplant patient kindly see, my lord.
Mr. Chaudhary.
At least, my lord, give a direction that, my lord, I'll file a petition, my personal appearance will
That's
be
not
accepted, my lord.
required, not required. You file an application. That's why you're not interfering at this stage.
My lord.
Right? But an application, you are aware what to do.
I am aware, my lord, even then, my lord.
Nothing
Because
will happen.
ultimately, it is a politically motivated case, my lord.
Nothing
If
will
you
happen.
not get
Nothing will
relief from your lordship, my lord, where will you go, my lord? Kindly consider
Well,
that
if it
aspect,
is-
no,
if
only
it is
for
not-
till 3rd of June, my lord, let it be stayed, then we'll see, my lord, later records come.
If it is not considered, come back to us, we'll consider. Okay? Yes, we wanted to know.
Yes, yes, Lordship. Just now I have received a report, Lordship, where it is stated that the accused person and the complainant, Lordship, appeared before the dispute PS and produced a copy of agreement between both the parties.
You want to know whether any case has been registered against the petitioner
No.
or not?
No, Lordship. Hence, the case inquiry was closed. They amicably settled, Lordship.
Not Mr. M. Sekia, counsel appearing for the petition. And Mr. K. Dutt, right?
Lordship.
And additional public prosecutor appearing for the state.
Not the amicable settlement.
On instruction, Mr. Das and additional public prosecutor submitted. That no such police case has been registered against the petition. On instruction before the dispute police station. In view of the above, this various verification may be.
Your lordship, that is not the amicable settlement. Whereas the some lordship, I have.
Mr.
agreed in my
Saikia, as on date, no police case has been registered. We are not saying on
But
anything.
lordship, this statement is to be recorded in the further proceeding, lordship. Therefore, lordship, my statement has at least recorded, lordship.
No
That
case
is
has
not the amicable settlement. It was done only the in pressure and in the premises of the police authority.
Mr. Saikia,
Please,
no
lordship,
police,
my
we're not
statement
going to
will
that.
be recorded, lordship.
Had there been any police case, we would have considered.
Just no police case has been registered, but
That's
there
what
is
you
a
have-
GD anti-lordship. In pursuance of the GD anti-lordship, one agreement has been made between us lordship in the premises of the police authority lordship. That is not the procedural lordship that police has always
You
shown
file-
fear lordship to
Mr.
be arrested.
Saikia, file criminal
Yeah.
petition, we'll consider. Here we will consider in past necessary order.
Your lordship. Yeah.
Madam, next table also indulgence, my lord. In my case, item number 14, my lord. Madam, one line may be added, my lord, another next state, my lord, that my prayer for interim stay of the petition will be considered.
The interim prayer to petitioners will be considered on the returnable date. If it is also relevant.
And
For a quick application. Is it by your words? It's a second application. And the next order.
Earlier, why it was cancelled? Some material,
Yes, ma'am. I have annexed the page 62, madam.
support ground.
Yes, ma'am.
Mr.
Yes, very much.
Get it from support ground when?
Lordship on 21st.
Okay, today is 13th, we will get in by 21st. On 21st for 11 cases. Support ground case number 58 of legal.
May I please your lordship? Lordship, this is a charge sheeted matter, lordship. The trial is at the appearance stage, lordship. And lordship, there are two accused persons. Lordship, the main accused person is already on bail and he's there, he's accused number 1 and he's participating in the trial. And I am the accused number 2, I am his second one. And the allegation against both the accused number 1 and accused number 2 is this, that both of them have abetted the suicide of the victim. Lordship, this is a 2017 matter case, Lordship. And Lordship, at that time, the accused number 1 was arrested, but I was not arrested because I was looking after the minor children.
Charge sheet has been filed.
Charge sheet file, Lordship.
When?
Charge sheet file, Lordship, on page number
29/3/2018.
29.
2018.
What is the case
17,
number?
page 17.
After filing of the charge sheet, what is the case number?
Now, Lordship, the case number is PRC 50 of 2020. Now, NBW is issued against me, Lordship, from recommending.
Why are you filing bail application? You have other mode. Which is a preferred criminal petition.
Lordship, I will appear before the conference.
That will not consider. You file criminal petition, that orders can be passed only in criminal petition, not in bail application. Or anticipatory bail application. Up to you. It's better for you in criminal petition, such orders will be passed.
Lordship, in that case, I will become, and I will.
On the prayer of counsel for the petitioner, Mr. Representative. Rest of this previous bail application. Filed by the petitioner. And PRC petition 50 of the 2. I have given both. Corporate affairs, taking liberty to find the appropriate work for the test of which liberty. Yes, Mr. Hussain.
My lord, the FIR has been filed by the son of the accused number 5. And accused number 1 is the brother of the informant. Accused number 2 is the cousin brother. Accused number 3 is the sister-in-law. 4 is the aunt. 5 is the mother, and 6 is the uncle, Lordship, paternal uncle. Actual fact, Lordship, I have.
Anyway, get the case there, Manipur police station case number.
19.
Bongaigaon.
19. Lord.
No, you have fixed another case from Manipur, which did.
Another case, Lord. 21, Lordship.
Have it on 21st.
21/5.
Lordship, mother and
Not
brother.
at this, let us see.
Lordship, in this case, Lordship, all the allegations are against accused number 1, Lordship. And we have filed application for accused number 2, 3, and 4, Lordship. and we are the mother-in-law, father-in-law, and brother-in-law of the victim lordship. And the accused number one, against whom all the allegations are, is the cousin brother of the accused number one lordship. There is no allegation against me. In fact, lordship, in the FIR, it is stated that when my sister-in-law, when my sister saw the accused number one in her house, she screamed, and then the accused number two came forward and fought the accused number one, but the accused number pushed him and went away. The accused number three went forward to help her, but the accused number one pushed him and went away. Yes, that statement is there in the FIR. And earlier, there is no allegation of any mental torture or anything against us. Lords.
Yes, tell us.
On 25.
There is no allegation against the petitioners number 1, 2 in the FIR.
2, 3, and 4.
Who are the FIR named accused in 2, 3, 4?
Lordship.
Read the FIR at page 12 in vernacular or in the English transcript.
No allegation against me. If it seems from the FIR.
This is from Bongaigaon.
Bongaigaon, Lord.
Anyway, get the case there. Same date.
25. Lord.
You know, kindly consider interim. No
Because there is an allegation that ultimately you have done something. Let us see.
Lord.
We'll consider on the next step.
Lordship, in paragraph 4, Lordship, I have written petition number 3. Actually, it should be petition number 2. I will be allowed to correct it.
Do it correctly. From 3 on 24.
Lord. 21. 21.
Take it. Yes, Mr. Sharma, you have not filed your reply.
Yes, Lordship, in these cases, Lordship, it is getting difficult to get hold of the IO, then IO. Most of them are transferred and changed. In the present OC Lordship, they are not acquainted with the fact, so it gets a little difficult. Most of the cases we have seen classificate way back. We have seen that. I've seen that.
FSL report is not there. Sharma, have you gone through?
Yes, sir.
FSL report is available.
Yes, Lordship, it is available. In the meantime, 4 PWs have already been examined. And next date was fixed on 3rd of May, Lordship, for evidence.
It's not here. Yes. We'll pass the order. What's your good name? Let me to. Be sure. Okay.
My pleasure. This is commercial quantity lottery, 75 kg of ganjas recovered from two other person lottery, from the one Rahul Amin and lottery Kazimuddin. And thereafter, after 1 month lottery, on basis of co-accused statement, I was arrested lottery after 1 month. And no recovery was from my possession lottery. Now the ground is that lottery we have filed a affidavit lottery, additional affidavit, but in the ground of arrest lottery that has not been mentioned in the notice 47 lottery. That have annexed in the affidavit law. And moreover, my case also covered by the Tupan Singh case law, the basis of the court statement. After 1 month, Lordship, I was arrested and now recovery from my lordship. On this, basically on these two grounds, Lordship, I am taking it. The recovery FIR date is 22/10 and my arrest date is 24/11.
Yes, Mr. Moon.
Lordship. Page 20 Lordship, notice Lordship. Page 20 of the additional annexed. Page 20.
Mr. Sharma, have you gone through?
Yes, Lordship.
Not finding the arrest memo of the petition.
Which I will check my. 15 rupees, no?
No, 47.
47.
Nothing just November 2024. Sharma. Go through it. Take a look. Yes, Mr. Munir, wait for some time.
Oh, Lordship.
This of commercial quantity 85 kgs of ganja Lordship arrested on 13/6/2023. The accused petitioner was traveling in a public vehicle where a packet was found in a bus going from Nagaon to Dimapur. Lordship. Now, when nobody confessed that whose packets were these, Lordship, the handyman pointed out that it belonged to my Lordship. That is how I am apprehended. Now, it was not found in my possession, it was found in a public way. Now, for last 1 year, 11 months, I am in custody. Lordship, charge has been filed, 4 witnesses has gone. I wanted to point out the deposition of the independent witnesses, which clearly show that I am being framed. Lordship, it is from page 22. So may I read the depositions, Lordship?
Just,
Permits?
just. Come to page number 30. Or before that, page number 29, last 3 lines.
Yes, sir.
The search party asked the last 3 lines. Page 29.
Uh, page 29, Lordship.
Deposition of PW2.
Yes, yes. The search party asks the passenger who is the owner of the plastic net. None of the petitioner has replied. So the police search party asks the conductor, handyman, and the driver of the bus who is the owner of the plastic mat. The conductor told that the accused is the owner of the plastic mat. That is what I
Then
submitted.
please carry on.
And he pointed out the accused person. The police verified from the accused where the plastic mat belongs to. And he had replied in belongs in positive.
Now come to the cross.
I was called by the OC Borpatar police station. He knows me. While I was waiting there before the alleged bus, the police had checked 3 or 4 vehicles. I was present in the place of occurrence till 10:30 to 11. At the time of checking, the OC of Borpatar, Depends Chandra Borua, Ostini Kos, and other constables, Home Guard was present. The ganja was not recovered from the seat where the accused was sitting. It was recovered from 4 rows of the seats behind him. It is not a fact that ganja was not recovered in my presence. Question whether the deposed, whether you have deposed as witness in NDPS case before? Yes, I have deposed as witness case once before in another case. Where you were listed as a witness in other NDPS case? Yes, I have been with the witness. I have witnessed search and seizure in 3 or 4 other cases with police team. We have told question. Who have told you the packets contain ganja? Police have informed me that the recovered substance is ganja. Therefore, firstly,
So this particular finding is evidence of the PW2
yes,
that though it was not recovered from your physical possession, but you have admitted the fact that particular packet made by Matt
yes,
belongs to you.
yes,
Where
but
police have recovered. And
Lordship,
in the cross,
Lordship,
that remains same thing.
Lordship will kindly see that in the cross, Lordship would kindly see he is a professional witness.
That
Because
should be a ground, a professional witness.
yes, not
He
an
was
independent.
he was an witness to
No,
the
normally
incident.
it has to be anybody from the public. Lordship would kindly see.
See, he may be there at this point. That cannot be that ground.
I was called by the OC Borpatar police station. He knows me. Therefore, the first line of the cross. Therefore, the witness was brought by the police itself. Lordship, it is not. He is not an independent witness. Whether he has deposed in other cases, in the first question says he has deposed in another cases. In the next question, he says that he has deposed in 3, he has been listed as witness in 3 to 4 other cases at page 31. Therefore, a witness can be judged by its quality. This witness is not at all trustworthy. Lordship. His credibility has been vitiated by this. Apart from not being independent, he is not at all trustworthy. And it is a public vehicle. That
Page number 35, second line.
yes, Lordship. I do not remember specific date of occurrence. I do not remember the registration number of the bus. When we checked the bus, we saw the accused was sitting on 3 seats ahead of the last seat. It is not a fact
Page
The
number 35, second line.
second line. When we inquired who owns the 40 and the 17 packets, or the accused told that all these materials belongs to him. Lordship, this is an official witness. I was posted
Or
at Borpatha police station. Moreover, Lordship, I am just claiming that I am already in custody for 1 year, 1 year, 11 months, Lordship.
Mr. P.P. Pora, counsel.
It's a long internation, Lordship, as per.
And Mr. P. Sharma are additional prosecutor. Petitioner namely. Such and such. Filed its application. And 13/02/2025 paying for this paid. Under section. In. NDPS case number 78 of 2023. Arising out of Borpatha police station case number 30 of 2023. Corresponding to the number 214 of 2023. In which he was arrested on 13/06/2023. Cars have been framed under section 20 within the HC of the NDPS. Range was arrested on according to the petition. He was not in exclusive possession of the NDPS material in that case. And on being pointed out by the conductor itself, public sentiment of the vehicle to the public. He was taken into custody. It is also submitted by the petition on behalf of the petition. That seems 13/06/2022. For more than
Today is 13th of
1 year,
May.
half months. Until the date of filing. Bill application. Until then. The prosecution has examined on 4 of its witnesses. Considering the detention in custody. And say. The petitioner has to wait for. As for the FIR. The date. Well, 06. Laws before the officer in the corporate district. The case is that. During an record checking. That. Akra Jan. Checking point. under Borkotar Police Station. From a passenger vehicle within bracket fast, bearing registration number AS21-C, like 9426. There was coming from Dimapur side and was proceeding to Namakan. In presence of independent witnesses, following the due process of law, $85.19 kgs of suspected ganja out in cannabis from 17 packets from 40 numbers, with 40 numbers of plastic match. Wrapped in a mat in the party. Was recovered. So we recovered from the state of being inquired. The passengers remain child. But improper identification. Please take your seat, Mr. The petitioner was apprehended. By order 17022025, the records of the relevant records will be focused for report of identification that the on perusal of the record, it is seen that the seized NDPS item recovered from the state public vehicle was forwarded to the FSL, and the FSL report dated K082023. Specify the received substance gave positive test for cannabis. From the records, it is also seen that the FIR dated such and such accordingly registered as Kolkata Police Department. 30/2023 and and on completion of the investigation, search it in state Kolkata PSP on 22/09/2023 by search it number 55. I think we can. It is also seen on the records of the case that after filing of the search sheet, it's a court of appeals. Actually, it corresponding to the number 2. The learned special batch. Let's say get started. The same was registered as NDPS case number 78 of the special NDPS. On 26/10/2023 cognizance of the office of the Prosecution. See. The learned special judge on 16/12/2023 and say NDPS case number 78. Frame under section, charge under section 28 of the CFP. It is also seen from the records that after 24/10/2024. In name prosecution. Evidence of court. Mr. Buddha, as of now, how many witnesses have been examined?
To my knowledge, Lordship, to my instruction is 4
That was the last year on.
last year. But while doing updates if required.
As per record, matlab, up to 24 till 24. PW 4.
Out of 10, নহলে খুব part time polytechnic.
PW নাম তো না
The accused has no criminal antecedents also as to
Who is totally examined. From the evidence. So for recording. But then a special test. The prosecution. There are materials against the petition. From the record to there is no such rate. On the part of such a rate. Once again. Right of the degree of the time. Such. Yes.
At least a lot. Today the 300 days in the custody of this person.
matlab
Mr.
service report awaited, matlab still matlab we have just one date, matlab on 8/5. Officer matlab 8/5/25.
List on 19052025. Decided the officer in charge of Jodhpur Police Station to the public prosecutor for the official abstract report regarding service of notice of this application. What is status of? The informant plus guardian of the victim. To be for case number 116 of. Okay, okay. Filling on the part of the concerned investigator, officer in the courts are considered the first consequence. And steps in this case was the stipulated 24 to 2. Copy of this order to Mr.
Fiction 19
Medical or PDSS can put it that not be a no liquid. Examination of
That is a loss. In this case, we have filed additional evidence.
Yes, your lordship. Your lordship, medical examination report, your lordship, opinion has been given, your lordship, wherein evidence of injury has been seen,
Just it.
flag, already flag marked it, your lordship.
Girl is only 3 years old now.
3 years old, your lordship, victim is.
We have 4 marks. Yeah.
Take your seat.
Mr. Parashar,
My lord.
this is another case. So the matter is waiting for FSL.
Yes, yes, regarding the DNA, yes.
What is the reason for the FSL?
Regarding the,
You have gone to the record.
well, it is regarding the DNA, my lord, especially
What was the requirement of FSL?
injury is there, otherwise. Statement of the girl is there, injury is there.
That's when it's available. So that is the. Okay.
May consider the bail materials available on record, my lord.
Mr. R. Ali, counsel appearing for the petition. And Mr. K. K. Parashar and the prosecutor appearing. Also heard. MS. Yan Kitas, Granadi, United States. Appearing for informant. Respondent number 2. Mother of the mind. But his application under section 4 of the PL filed on 19th June. But the petitioner is explained in special box case number 136 of the registered under section 376 indicate the IPC ready to check the feature of the in which you are the registered person on 11/06/2004. Rising out of profit of position placement. 238 of the as per the FIR, it is 1106, as per the FIR, it is 1006. 1106-202. Laws before the officer in charge of corporate of certain police station by the informant. The cases that informants minor death at around 955 and 1006 to the went to shop off from the full money tax, which is nearby, to purchase chips. While her daughter was in the said shop, the accused petitioner he suffered with about 3 years. Induced her by paying some money and telling her that he shall also pay her money to buy chips, and took her to his house, in which the accused petitioner sexually assaulted her minor daughter while no one was in his house. Later, when the minor daughter returned to her home and the informant inquired from her why she is late, why she was. She told in details about the act of the accused patient. The affair immediately interrupted. By order, it is 25-0-2025, report call for the records and report of blood expression. As the petitioner is in custody since 11-06-2024, considering the length of detention, petitioner is figured. By filing an additional affidavit, it is also submitted on behalf of the petitioner that no notice under section 50 and 50A of the statute was served the accused petitioner filing the case. At the time of filing, on perusal of the records, it is saying that on receipt of the information from the informant, the police authority from Bolpeta Police Station immediately informed the concerned CWC Bolpeta about the incident. The said FIR of the petitioner, the informant was accordingly registered as Bolpeta Police Station case number. On the same day, the minor victim girl was produced before the learned judicial magistrate first class work better. And her statement, same day, 11. 11, in the same day, the minor victim girl was produced before the authorities of the Operating Ali Ahmed Medical College and Hospital for her medical examination. During her medical examination, the doctor found the following report. Dated 11th of September. Yes. On 12/6/2024, the minor victim girl was produced before the land judicial magistrate first class. And her statement under section 164 serviceable record, in which she implicated the petitioner and also explained how the accused prisoner committed sexual assault on her. During investigation, police seized the original birth certificate of the victim girl, which indicates that the date of birth of the victim girl is 05/02/2021. And it was issued by the registered attendant Operating Ali Ahmed Medical College Hospital on 04/09/2021. In September 2021. As such, on the date of the incident, in 10/06/2022, the minor girl was just about 3 years. About 3 years old. Police, after completion of the investigation, submitted the search before the line. Special Judge Fox Supervisor. And on 17/09/2024, the special judge in said special in the special Fox case number 136 of 2024. And I think of a corporate affairs. Took cognizance of the offense under section 376 of the LBC. They did section 8 of the PF principle. But on proper application of the concerned investigating officer, indicating that instead of section 376 of the NDPS, reading section 6 of the POC. The subset wrongly back to section 8 of the POC. I ordered it at 24/9/2024. The order will be corrected instead of section 6 in the interlink. There is section 376 of the NDPS, there is section 6 of the POC. Instead of 8 of the. From the records of the case, it is also seen that on 11/06/2024, you notice under section 50 of the CRPC was issued on the petition indicating him the sections under which he was arrested. I section 276, I read section 4 of the POC and say for the page and also inform him that he may submit petition before the court for his bail. The petitioner on 11/06/2024 itself received an its order. The concerned investigating officer on 11/06/2024 also served notice under section 50A CRPC to the brother of the accused petitioner, Martin Saha, who duly received the copy indicating him for the arrest of the petitioner on 11/06/2024 in said Profeta PH case number 6. Like no brother.
My lord, charge sheet submitted, my lord, beyond 90 days. On 93 days, he was not informed, my lord. And legal aid counsel was not appointed, my lord.
So some of it was duly reported.
On 93 days, my lord.
So there, it has been pointed out.
And that although notice was issued, my lord, ground was not there. In this point, my lord,
Very much clear. That is why you have seen here.
my lord, I am relying on judgment, my lord. Very recent judgment.
That we have seen.
Mayor furnishing, my lord, notice
You have
will
been
not serve.
informed, that's why you can approach the court for your bail.
No, after, by legal aid counsel, my lord, after charge sheet. Bail was filed by legal aid counsel. And order, my lord, dated 10/12/2024, my lord, by additional sessions as my lord, say that final charge sheet has not been submitted till then. Single accused, my lord. This is the record of the learned trial court.
Yes, yes, FSL report is everything. That doesn't mean the charge sheet, that is the supplementary charge sheet will come. You were arrested when?
11/6, my lord. Charge sheet submitted 12/9.
It was discussed on 10/9. Clearly mentioned. By the IU. Yes. Mr. Parashar.
Yes. Okay.
Go through and tell us at 2 o'clock. You have marked it. Go through and tell us.
Yes. My lord, accused was arrested on, my lord, 11/6/24, and his 90 days was completed on 9 September. Now, charge sheet was submitted on 12 September, on 93 days. Now, when, my lord, 60 days or 90 days over, my lord, then any application should be there on 91 days. But I have said no such, my lord, application was pending. But his PR must be there either already or through application on 91 days. That once
submitted. His right was gone. And no such application, no such prayer was not here. I have checked whether no such application is here. So. Yes, it is just submitted. No such application. Now he cannot reflect that right government. Once what now he cannot avail that right.
Any authority in that regard? Any authority in that regard? Hmm. No, that has to be counted from the date of the production, first production.
The day he is entitled for social bill, there has to be a pending deed or a prayer.
And where is the decision of Justice Lokur? His lordship decided in this court. The check is from Assam only.
Yes, it's the last.
What is the finding there?
Also goes to the consider case also, it is also list here. Consider. 1994, 410. What is it? Nine.
Yes, Sanjay, it was case 1992 4 SC.
Yeah, for SCC. I'm sorry, Lordship, 94 5 SCC 410.
Ninety-four 5 SCC.
Yes, 410. Yeah, it is specifically held. There has to be a application pending or at least one oral submission should be there.
No, I think that thereafter the matter was decided by his lordship.
Yes,
Justice
yes,
Lordship.
that is Lordship Rakesh Kumar Paul. I have the judgment, Lordship, but the citation, Lordship, it does not tell you.
You are relying, Sanjay, that which,
Lordship paragraph,
167 2, right?
yes, there, Lordship, the paragraph starts with, Lordship, the indefeasible right of the accused to be released on bail. Paragraph 53, subsection 2, probably, Lordship. B, yes, Lordship.
Continue.
Yes, Lordship. That is stated, Lordship, the indefeasible right of the accused to be released on bail in accordance with section so and so of the TADA Act, read with section 167(2) of the Code of Criminal Procedure, in default of completion of the investigation and filing of the challan within the time allowed, as held in Hitendra Vishnu Thakur, I have already mentioned, Lordship, is a right which ensures to and is enforceable by the accused only from the time of default till filing of the challan. That is specific, Lordship. And it does not survive or remain enforceable on the challan being filed. So once, Lordship, charge sheet is filed, that right goes away, Lordship, if he has not availed of it, Lordship. If the accused applies for bail under this provision on expiry of the period of 180 days or the extended period, as the case may be, then he has to be released on bail forthwith.
the right of the accused to be released on bail after filing of the challan, notwithstanding the default in filing it within the time allowed, is governed from time of filing of the challan only by the provisions relating to the grant of bail applicable at that stage. So Lordship, he has to make that prayer either orally or in a written form in a bail application in the period when he is entitled, Lordship. But once charge sheet is filed, that indefeasible right goes away, Lordship. That is also affirmed by the Rakesh Paul case. There is one more citation, Lordship, the Supreme Court. That is Lordship 96 1 SCC 432. 1996 1 SCC 432. That is Lordship State versus Muhammad Ashrafat Bhatt. There Lordship, it has been stated, such right, that is of default bail, Lordship, is enforceable only prior to filing of the charge sheet. But the accused did not avail himself of the right, and charge sheet in the meantime has been filed. His right to obtain statutory bail under 167(2) proviso A or B has been extinguished.
So the other case, Rakesh, some case,
So I don't have the
citation, just give the Rakesh Singh, I think.
Rakesh Kumar Paul versus State of Assam.
2017 5 SCC. 67.
Not 67. 67.
67, no? Fifteen. 15 SCC, man.
17 volume.
Mr. Sharma, you got it?
Lordship.
There are 78 applicants.
My paragraph doesn't match, Lordship. That is the difficulty.
There are 78 in the FCC DP.
Lordship.
2 lines. You are looking at where?
Lordship, this is just an unreported person, Lordship.
Go to para 46.
Lordship, the part written by Honorable Loku.
Yes, there are 2 parts. One is dissenting judgment, one is.
Yes.
There are 3 judges been present.
Yes, yes, yes.
Read para 40. It starts what? The sentence starts with.
It was submitted.
It was,
In your case also, it will be same.
yes. It was submitted that as of today, a charge sheet having been filed against the petitioner, he is not entitled to default bail, but must apply for regular bail. The default bail chapter being now closed. We cannot agree for the simple reason that we are concerned with the interregnum between 4th January 2017 and 24th January 2017, when no charge sheet has been filed, during which period he had availed of his indefeasible right of default bail. It would have been another matter altogether if the petitioner had not applied for default bail for whatever reason during this interregnum. There could be a situation, however rare, where an accused is not prepared to be bailed out, perhaps for his personal security, but since he or she might be facing some threat outside the correction home or for any other reason. But then in such an event, the accused voluntarily gives up the indefeasible right for default bail, and having forfeited the right, the accused cannot, after the charge sheet or challan has been filed, claim a restriction of the indefeasible right. But that is not the case insofar as the petitioner is concerned, since he did not give up his indefeasible right for default bail during the interregnum between 4th January and 24th January 17, as is evident from the decision of the High Court. Yes, at that time, his application for bail was pending, Lordship, in that period, Lordship. Therefore, it was held to be that he is entitled for default bail. But in this case, Lordship, there is no such application, Lordship.
Exactly. That is the reason we are asking you to read them.
Yes.
Clarify.
Yes, yes. That is there, Lordship. That is also the, all the judgments, Lordship, refers to the same.
Particularly Sanjay Dev.
Yes, particularly Sanjay Dev.
Yes, Mr. Ali, what we have. You have seen that. You are relying on which judgment?
I have given, my lord. On Supreme Court judgment, my lord.
50, that 50 is applied.
But Mayor, my lord, Mayor issuing notice under section 50 will not suffice, my lord. The Honorable Supreme Court said, my lord. In a prescribed format of 50, my lord, that is not sufficient. Now, our High Court also, my lord. Here also, my lord, 50 notice was issued, but without, my lord, mentioning the ground and any other, my lord. Just by heading section 50, notice was issued.
There is a difference in other cases.
The principle will be same, my lord. In this case also, my lord, 50 notice was issued, my lord, without citing any ground, my lord. Paragraph 8 and 13, my lord.
Come to that. Clarify.
And here, my lord, in this case, my lord, he was arrested. He was not, my lord, provided legally, my lord, counsel. And after such submit, when the cognizance was taken, my lord, on that day, my lord, legal aid counsel was provided, my lord. And he filed the bail application. So even he was not informed, my lord, regarding, my lord.
You are making statement because somebody is saying, or you have gone through the records thereafter making your statement?
In the office, in the order sheet, my lord, I have annexed, my lord.
So, Mr. Sir. For an experienced lawyer, Mr. Ali.
Thank you. The production of the report. Huh? On the day of forwarding, my lord,
What is the,
the accused informed that he is entitled to plead legally if he is unable. The accused also stated that he has already engaged the advocate.
yes, give us the record. Sufficient. We pass the order. You have yourself paid. Before making statements, just go to the record and make statements thereof.
Now 17(9) order is defined, my lord.
We'll pass the order. Yes,
Take the record, but that arrest memo and 47, I'm sorry, 47 notice is not in the record. Lordship.
in the record.
Not in the record. In respect of the petitioner, in respect of other co-accused,
Yes,
it is there, but in respect of the present petitioner, not there.
that is what. Or is Mr. Munir, to one extent, there are materials against the petition. And the other regarding section 50. It's not available before us. This has come from district judge, the learned special judge.
It will be 47, Lordship.
That's what, it hasn't come here. Because subsequently arrested, right?
Lordship, yes.
And also not getting your forwarding report.
Forwarding report, Lordship, as I find, Lordship, after going through the record, Lordship, there is a typographical error, Lordship, while producing that. It just says, Lordship, Lordship, can you see the date of the forwarding report that on page 9, Lordship, of my bill? 24/11/2024, it has been mentioned, Lordship, but the actual in the notice, Lordship, it has given 22/12/2024. And while, Lordship, I was going through the charge sheet, there also, Lordship, it has been shown as 22/12/2024. Initially, we don't have all this thing, Lordship, so we have mentioned the date of arrest as per the forwarding report, 24/11/2024. Lordship, may ask the learned PP to, Lordship, get the information regarding the arrest memo and 47, Lordship, from where?
So it will be available in the, because it is certificate, it has to be in the record.
Record, he didn't nahi go pare to. Scan book nahi go pare to.
All the reports are put are.
All may be, in scan copy, Lordship, all might not have been come, Lordship, that may be also point, some may be left in the original record. Normally, enter record to nahi pay for that. A ketaman particular order or charge sheet and the main with a different. And on the other hand, we don't have this.
But Mr. Aswin, counsel acquiring for the petition. And Mr. Patient, my. By order dated. Zero 7042025. Could call for the record. court called for the scanned copy of the records relating to Puragaon Police Station. Case number 89 of April 2022. Wherein charge sheet number 05 of 2025 at 31 2025 was filed. All for justice. On the 10 copy of the records of NDPS case number 13 of 2025. Allow me to account of Puragaon PS case number 89 of 2022 corresponding to PR number 1320 forwarded to a annexation that Oregon on 25/04/2025. Record pertaining to arrest of the petitioner. Fazlur Rahman, right?
Lordship.
Son of Moin Uddin. And his production before the first production before the court. Not be found. So in the search sheet, the concerned investigating officer submitted that the accused petitioner Fazlur Rahman was arrested on 22/12/2024 and was also put was arrested under section 20 within bracket small k within bracket 5 on within bracket C public 29 of the not this fast forward the court on 22/12/2024. We have the call for the scan legible copy of the records of program case number 89 of 50. Corresponding to the report of the official test in bracket NDPS of section 35. As well as up-to-date records of NDPS case number 13 of 2025 from the state learning for it's order people to the architects list on 28th of May.
Lordship. In the meantime, we will try to obtain the certified copy, Lordship. Much obliged, your Lord.
Please, Lordship. Lordship, kindly pass over the matter for the day only, Lordship.
And declare the council for the list of the
Obliged.
May I please your lordship? Your lordship, 483 bail application. Your lordship, there are two previous orders in the same case with regards to the same affair. May I give you the copy? Your
You have not filed objection.
Yes, I love objection. This is in the record.
It's not available on record.
When the earlier bail of the petitioner was rejected by this court,
Ajit,
earlier the petitioner approached after the minimum charge for his bail when it was rejected.
Your lordship. Yes.
Justice,
25/8/2022, your lordship.
page
Page number 78.
Yes.
May I please, Your Lordship? Your Lordship, on 25 to 2022, a truck was intercepted near Kanapada region, which was driven by one driver named Kumar Singh. Thereafter, after 7 days of the truck being intercepted carrying 405 kilos of ganja, these 3 persons, out of which 1 person was the owner of the truck, were in Guwahati. The NCB approached them in page number 34 of my petition, Your Lordship, in paragraph number 28. The NCB approached them on 4th of March 2022, and thereafter they immediately asked them to occupy for a 67 statement, Your Lordship. Thereafter, solely on the basis of the statement of 67, that is of the truck driver and the rest 2 accused persons, the present petitioner before Your Lordship has been implicated. Now, Your Lordship may see, with regards to this statement which was mentioned by the other accused persons in page number 41, Your Lordship. In page number 41 of the petition, Your Lordship. In page number 41, paragraph number 36. In 6th line, it is mentioned, Your Lordship, upon analysis of the CDR of mobile number belonging to accused Kumar Sunar, call links were established with mobile number of accused Debojit Saha and accused Bishwajit Sharma. On analysis of CDR mobile number no call links were found with any other accused person or suspect. This is the NCB's final report, Your Lordship. Furthermore, Your Lordship, please turn to page number 45, Your Lordship. This is the main crux of our case, Your Lordship. Page number 45, paragraph number 45, Your Lordship. In page number 45, the same NCB writes, and the last from the bottom 3, paragraph number 45, it has been established that Shankar alias Rahul is accused Bishwajit Sharma, and it has also been established that mobile number so and so of Shankar alias Rahul, as given by Kumar Sunar, who was the driver, belongs to accused Bishwajit Sharma. Your Lordship, which means there is no direct evidence or circumstantial evidence which leads the present petitioner to the instant case, Your Lordship. Neither I am the owner of the truck. I was only present with the owner of the truck who came to Guwahati after his driver was arrested in connection with a case carrying contraband substances, Your Lordship. And therefore, at that point in time, I was taken to the office of the NCB, and 67 statement was taken of all the 3 individuals, including me, and a notice was served. I'll go to the notice part by the end, Your Lordship. Your Lordship also may come to page number 57, Your Lordship, of the same NCB's report, Your Lordship. Page number 57 in F, page number 57, F, Your Lordship. F says that call links have been established between the mobile number of Kumar Sunar and other accused person Bishwajit Sharma and Debojit Saha, which corroborates the voluntary statement of each accused, Your Lordship. And at the end, and also, Your Lordship, if you see page number 61 and 62, where the NCB has tried to brought down the role of Shankar Devnath in this particular case, here the entire narration is about the driver who has carried the drugs, and also about the owner of the truck and 1 person named Bishwajit Sharma. It has already been mentioned in this particular document itself that Bishwajit Sharma and Debojit Saha were trying to express themselves as Shankar Devnath, and whereas there is no direct or circumstantial evidence connected to Shankar Devnath, Your Lordship. This is one part with regards to the merits of the case and how the present petitioner is connected, Your Lordship, without having any kind of circumstantial or any evidence to any remote extent, Your Lordship. Furthermore, Your Lordship, may you kindly come to page number 81, Your Lordship. Page number 81 is the order of the Honorable Supreme Court. The order dated 30/8/2024, Your Lordship. Page number 81, Annex 5. Indeed, Your Lordship. Page number 81, Annex 5. The order of the Honorable Supreme Court, paragraph number 4 reads, however, the trial court is directed to expedite the trial and conclude the same, preferably within 6 months from the date of the receipt of a copy of this order, which this order was passed on 25/8/2022, Your Lordship. And in the reply filed in the instant case by the petitioner respondent side, NCB, if Your Lordship sees paragraph number 4 of the objection filed by the NCB, where it is stated that in paragraph number 4, it is stated that also none of the 6 prosecution witnesses examined till date have any role in the arrest investigation of the accused petitioners, as such the contention of the petitioners, Your Lordship. Which means even after a direction by the Honorable Supreme Court, none of the witnesses have been examined so far, and the period of detention is 3 years. 3 years plus, Your Lordship. 3 years, 11 months, and 8 days, Your Lordship. This is the first and the second contention, Your Lordship, with regards to the merits of the case, with regards to the period of incarceration. And the third point is, Your Lordship, with regards to the two orders which I have submitted, order of Debojit Saha and Vishwajit Sharma, passed by the Honorable Guwahati High Court, where Vihan Kumar judgment and Prabir Kokaste was discussed, and the notice which was served after taking him into custody without any grounds of arrest, Your Lordship, are the three main grounds for our seeking bail and protection in this Honorable Court.
What do you have to say about Bihan?
Lordship, Lordship, yes, Lordship, I have gone through the notice, Lordship, grounds of arrest were not there, Lordship. That is why co-accused bail granted, Lordship. And regarding Lordship on merit, Lordship, sufficient materials are there against them.
Now, what do you have to say, the provisions of as they has been held by Bihar, has not been complied with, the co-accused have already been released.
Yes, Lordship. For not complying section 15.
Same is the case with the petitioner law.
Lordship, and they have not mentioned this ground in their petition, Lordship. Like, section 15 not complete.
Have not raised the issue.
Your Lordship, by parity of judgment, I would like to orally submit, because I already submitted the orders, Your Lordship. Parity of orders.
And Lordship, I have another submission. He is found involved in another case of Tripura, Lordship, which we have mentioned in our objection, Lordship, Tripura, PRC case number 308 of the 2022. And Lordship,
PRC case number
308 of the 2022. And Lordship, we have received one letter from department. Lordship, department has received one letter from Rani Bazar Police Station, West Tripura. May I submit?
but here the petitioner comfortable.
Your Lordship, with regards to the Tripura case, this is not connected with the instant matter in any remote sense, Your Lordship. The only contention is that the petitioner was behind the bars and summons were most probably issued which were not served to the petitioner, Your Lordship. And therefore, from behind the bars, he cannot appear, and therefore a warrant is pending which can be later on dealt with. After which is these two cases are separate, Your Lordship. There's no interconnection link, Your Lordship.
First year. Third. Mr. P. Luxford. Also appearing for the petition. Nemeth and Dekha are also appearing for respondents. The petition. Late person. Is an accused in NDPS case number 189 of 2022. Arising out of NCP crime number 04 of for the rest of 05 03 2022. State NCP crime number against him and the Prosecution. Two other. Two. Third and the sixth. 20 in bucket P in bucket all the 29 frame of 711 at trial of the case. Since the petitioner is in custody, the file from 45 and evidence of prosecution is open up. As they begin custody for the petition. Spraying for spray. It is also completed by the petition that earlier the Honorable Supreme Court by its order which page
Page number 81, Your Lordship.
first in special leave petition will be a criminal trial of the dated 30/08/2006. Directed for 12 expedite the trial on the same preparatory within 6 months from the date of receipt of the copy of the statement. Or the Prosecution, NCB. Failed to complete trial. And evidence of many prosecutions. Natural Astral and counsel appearing for the prosecution. Also submitted. That two of the two accused. The Precedent Sharma and Deposit Saha released by on release on bail by 14 and 10 of this court. By the orders that is released in the court. That's speaking. For non-compliance. There is also pointed out by Mr. Raspert and counsel that the present petitioner was arrested along with state level take the precedence and the inside and security. And even if the petition. Where is the records of the case that was called? Records of NDPS. Matter relates to recovery of 405.270 kg of ganja containing 42 numbers of plastic packets from the position to the petition of another 280 by the NCP. On. Means data when it was seized. $25. Petitioners were arrested. Why you have 7/5? Record reveals you that we have been voting for the first time on 27th of April. Mr. Lasker,
Your Lordship,
you were arrested on 5th of
on fifth, Your Lordship.
you have been produced before the learned magistrate for the first time only on 27th of March, February. How come? Something is wrong. Produced for the magistrate on 27th of February.
No, your lordship, on 5.3, paragraph page number 38. Page number 38, were produced before the Honorable Sessions Kamrup Metro with prayer for judicial remand on 5/3/2022, your lordship. Page number 38, paragraph number 32.
Overview of content. It is also seen from the records of the case that offense report was already submitted. Charge prima of the victim. Also seen from the records of the case that after prosecution witness, the trial court has already recorded evidence of six prosecution. Further, the police who were already cross-examined by defense, including further, the records revealed that Ms. Baker, the record before us doesn't tally with whatever is in the offense report. Mr. Luster, we have marked 2 pages. Tell us whether section 50 has been complied with. Ms. Defa, you also have a look. It's similar the case with the other 2 petitioners who have already released on. That is the memorandum of arrest. Kindly read the memorandum of arrest. Kindly read for. Kindly read aloud.
Your Lordship, memorandum of arrest. In consequence of connection with the recovery of seizure 405 kgs of ganja, the Narcotics and Psychotic Substances Act on 25/2/2022 near Metro Hospital, Khanapara, I do hereby arrest Shankar Devnath, son of Tirani Santa Devnath, resident of West Tripura under section 42 of the Narcotic and Psychotropic Substances Act on 4/3/2022 at 17:40 hours at the Office of Narcotics Control Bureau, Assam, on reasonable brief prima facie proof that the seized goods, articles, documents are liable to confiscation under section 60 of the Narcotic Drugs and Psychotropic Substances Act, and aforesaid Shankar Devnath is liable to proceedings under section 8C to be read with so and so for contravention of the provisions of the Narcotics and Psychotropic Substances Act 1985, which have already been duly explained to him or her. The aforesaid person is being forwarded to competent authority with 24 hours for his remand in judicial custody.
Now see the notice.
The notice here, Your Lordship. Shankar Devnath, son of Taranikanta Devnath, village Nagav Para, Rani Bazar, NCP Guwahati, under section 8C 20 and 29. You are hereby informed that you are arrested in connection with the above reference and the case is non-bailable, so you are forwarded to the court. You must submit petition before the honorable court for your arrest. Your Lordship, this is the 50 CRPC notice.
The arrest memo have already been served to you, specifically providing the grounds, explaining the ground. And also the arrest memo under section 50 is very clear, right? Now, the arrest memo, it is specifically mentioned, right? Which provision you have been arrested. It is not only the heading, the such and such and such. Here they have explained. Similar notice was also issued to the other 2 accused. The record itself, they have received on the similar date.
Your Lordship, I would like to humbly submit certain things here. With regards to the memorandum of arrest and with regards to the section 50 notice, there is the judgment of both Vihan Kumar and Prabir Purvastya, which states that there is a difference between reason of arrest and ground of arrest, Your Lordship. This is the reason of arrest. We are contending on the ground of arrest, Your Lordship. In the Prabir Purvastya, if I read the judgment, Your Lordship,
You have received the grounds of arrest or the reasons of arrest and the section 50 notice together.
No, indeed, Your Lordship. I beg to differ, Your Lordship, with regards to the ground of arrest and reason of arrest, Your Lordship. We have received the reasons of arrest, but the Honorable Supreme Court has repeatedly mentioned in both the judgments. I would also like to read out the paragraph from the judgment where it is said, may I please read out, Your Lordship. Prabir Purvastya, paragraph number 29. The language used in Article 21 and Article 22(5) of the Constitution of India regarding the communication of the grounds is exactly the identical. Neither of the constitutional provisions requires that the ground of arrest or detention, as the case may be, must be. Okay, sorry, Your Lordship. Just one moment, Your Lordship. Not this paragraph. And Your Lordship, paragraph number 22, citation 2024-6 SCR.
Yes, we know.
Indeed, Your Lordship. The right to be informed about the grounds of arrest, Your Lordship. Here in the arrest memo, the reasons of arrest has been mentioned, Your Lordship. Our case is on a thin line with the differentiation between grounds of arrest, which has to be reason of arrest, and grounds of arrest, which has to be mentioned in the section 50 CRPC notice in comply with 47 BNS, Your Lordship. Here only the reason is being mentioned why we are arresting you, Lordship, under which section. There is no grounds that you are connected in so and so matter with regards to the Lordship. Paragraph number 49, my lord.
The result of the record. That those notice and protection is here. Seven. Petition 4-3. But doesn't complete the ground has been established. In the case of Pula Varchik, and differently the situation of profit for tax. Yeah. It's not conflict. Many of shall not be repeated. Don't try. Okay, free, but okay. It's for the. Well, definitely. The. Well, say that the PS get. And go for it. Would be cool. During the time. Really. There's also the fear. There are a lot of instruments. Which are the it is not. So we have. I think. That it with that basic with petition on date say NDPS case number one, it will have to procure the evidence appearing the time. Of the that that's all. Let's go. Take NDPS case number one. At this stage. Instead of understanding from the right. Place the 44 the communication of the Rani Bazar officer in charge. Rani Bazar police station, West of Gujarat. That's the 799 and then 06 indicating that the petitioner the starts of it. Rani Bazar police station. West of Gujarat. C public service case number PRC in the category W 308
Lordship, regarding case number PRC, I have some confusion, Lordship, whether it is 22 or it is not visible, Lordship, 2023.
Out text.
Much obliged.
Have you been?
The daily application was also fine on the NDPS on the last application, the update LCR was called for.
Okay.
As of today, your lordship, he is 651 days behind the bar. And on the last occasion, the bail application was rejected on the wrong statement made by the engaged counsel that the judgment was being awaited and the entire case has been complete. But later on, it has come to the notice of the court that the prosecution witness, 4 number of prosecution witness has been examined till date, and it is still going on. Nothing has been whispered against the petition till date. And also, a habeas corpus WPC criminal petition is also awaiting in this case.
for the adjournment, whereas the argument has been placed before your hearing. The other side has filed an objection to the bill, whereas they have in the para and page number 8, they have mentioned that the accused person is if allowed to go on bail, there is possibility of hampering the investigation, tampering of the evidence. There is at this stage of time, also there is no chance of hampering of the evidence. The full number of prosecution witness has already been examined. And he will be allowed to go on bail, your lordship, 651 days behind the bar, and he will be allowed to prosecute his case in a fair manner, because he's not being able to conduct the case with his against lawyer also. DLSA has been appointed. Prosecution which was number 4 was being examined and also cross-examined. Now it has been fixed for further revision.
Your reason for releasing the accused is only on the ground of delaying prosecution.
That is one of the several grounds. Other grounds of lawsuit I have mentioned in my petition at the para number 11. The mandatory procedures of the NDPS were not being complied with in this case. There, because the contraband items were not being weighted in the registered measurement firm with the modern equipment tools, including the UN testing kits were required so. And no chemical test was also conducted as per requirement of the standing order dated 1/22 dated 15/3/1958. That is a standing order which was not being complied with. And moreover, Lordship, the seizure was carried out in connection with the present case by the investigating authority, but the investigating authority had not seized the day-to-day entry register of the lodge, where the accused petitioner were halted, as well as the contrabands were stored and recovered.
Mr. S. Ahmed, counsel appearing for the petition. And MSN Dectal and a petition for. Very plan, any consideration.
Lordship, on behalf of
Petitioner nameless person. Filed its application. On 24/0/2005. For his pay. NDPS case number such. That's it. Arising out of NCP modified. Presently pending. Right, before the NDPS committee decision. Session that number. Petitioner earlier approved this book. For his pay. With the deputy.
Fourteen, 11, 24, page 34.
Page
34. 14, 11, 20, 20.
Page number.
Page number 35.
Fourteen 11/2024. Due to wrong submission, the part of the council for the petition. Wherein. Was submitted. The trial of the case. Complete. Mr. Ahmed, counsel appearing for the petition of clear before the court. Okay. Trial of said NDPS case number 16 of the 2024. Still going on. And as on date, the full prosecution witnesses. Like, for the magistrate. Oh, okay. That is contented by the petitioner. Is contained on the petition that. The. Petitioner has been falsely implicated in that case. And was just a bearer of the consignment containing alleged compromising items. And was not aware of the position of the compromising item at the time over it. As well as the right investigation. There is also alleged in the of the petition that the investigating authority did not comply with the procedure of SARS-CoV. The standing order dated 15/03/1988 pertaining to the quantity in respect of NDPS item recovered. And since he is in custody since the one will be for such cases. The petitioner shall. Matter relates to recovery of 0.673 kgs of heroin from 59 numbers of soap cases. 0.673 kg of heroin and 2.350 kg with 59 soap cases. From the conscious position of the petition from room number 16 of Goswami Lodge near downtown hospital Morning on 01/08/2023. Filed the petition causing the state law of the wrong with another who arrived at pay from Manipur in a market bearing registration number MN P57. On being tested by the drug detection kit from each of the 59 suitcases, it gave positive result for heroin. According the 59 suitcases, along with the NDPS substance, let's see. On 08/08/2023 from the purchase position of petitioner and Vijay Gupta, they say to number 16 of 7. Following the deposit, making proper Caesar report and XRP and along with to the NDPS side. The Maruti Gypsy vehicle of the petitioner his mobile driving license, Aadhaar card, Bank of Baroda card, like Rupee debit card, driving license, cash amount. The FSL report. There is 6/11/2023. Cotton industries items recovered from the position of the petitioner gave positive result to be heroin. After completion of the investigation, offense report was submitted. Before the land. Procedural NDPS. Medical system. Against the petition. Another. Under section 8, it will be fixed. Of the 21, fixed to 29, which is 1985. No, different. Yes, ma'am, when it was filed,
Lordship, objection.
offense report.
Lordship, 25/1/24.
25/1.
24, final complaint filed.
Difficulties you have not marked the file. We have to find out when the charge was filed. You stated so in your
It has not been mentioned, Lordship.
difficulties on that.
Lordship, on 23rd,
On 23/02/2024. As under section 21C. Public 29 of the NDPS. Act. I am against the petition and the other. Affidavit. It is seen that after framing of charge on 23/02/2024, in say NDPS case number 16/2024, and I think with the NCP. The first, the evidence of prosecution of witness number 1 was recorded on 0205-2024. Then up to 0305-2024. The prosecution is examining the four of its witnesses. How many have to be examined?
Lordship, your Lordship, the final complaint has not been elected, Lordship.
You have not stated in your
Lordship.
the difficulty. Neither you have mentioned nor it's available in the record. Considering such the detention of the application in such.
Lordship, I have submission, Lordship. He is involved in two cases, Lordship. We have filed our objection, Lordship. Two number of cases already, entities cases already, Lordship, registered in the name of the petitioner, Lordship.
In one of the cases, he has been already been acquitted here. And other trial is going on.
Case its trial is going.
Okay.
What are the case number? Case number.
Which one is it?
File number 52. Bracket 08/2018 dated 14/08/2018. In that case, he has been acquitted.
No, he's enlarged on bail.
He's enlarged on bail. In this case, trial is going on. In the other case, FIR 24/22, 2005-15, dated 16/2/15, he has been acquitted.
Numbers are not before us. Do you have the number?
No, I will obtain. They
Next
will not
time- Next time, don't fight. We'll put heavy calls. See how much time you have incurred.
Okay.
Either the
Three days
report
time.
is here, final report is here.
Okay,
Which is not the way Ms. Deca will not allow to appear before substituting Mr. Cal like this. Don't file it. Difficult for the court.
Department prepare objection, that is all.
This is not the way. Without complete out. And it's there.
What the cases we have specially mentioned in the petition.
Already two cases. In two cases. Petitioner is found to be accused under the NDPS. I'm not confident hearing. That one of such cases, the accused, the another, right? It's-
Oh.
Ms. Deca, from next time, no,
Okay.
at least not before this.
Okay. I'll agree.
May it please your lordship. So this is a regular bail application. This petitioner in jail custody from 28/9/2024. Today, lordship, 228 days, lordship. Here, lordship will find the FIR on page 17, lordship. 13 bottles of his Histacot cough syrup recovered from the bag of this petitioner as per FIR, lordship. Then, on the strength of this FIR, lordship, he was arrested, lordship, and forwarded on forwarding report, lordship will find on page 21, lordship. Forwarded on 28/9/2024, lordship. In the forwarding report, lordship, they have said the enclosure they have given, lordship, arrest memo, inspection memo, accused challan, accused notice, checklist, lordship. So since I couldn't go through the record, lordship, so the ground of arrest, lordship, whether that has been mentioned in the notice or not, that has to be taken into consideration, lordship. So for the lordship notice 47 is concerned, I have annexed one Xerox copy, lordship, that is on page 20, lordship. Since forwarding report, lordship, say they have issued notice, lordship, arrest notice, lordship, whether it is under section 47 or 48, lordship. Now, this case has been charge sheeted, lordship. Charge sheet, lordship, will find on page 23, lordship. This charge sheet was submitted on, lordship, filed on lordship, 17/12/24, lordship. And in the charge sheet, lordship, there are as many as, lordship, 10
Yes,
witnesses.
Mr. Das.
Lordship, I have seen the scan copy, Lordship. 47 grounds are not there.
Is it there, Mr. Das? No. Okay, to grant you bail,
Highly obliged.
2 lakhs of rupees,
Can it be?
one government employee,
Worship 1 lakh can it?
sufficient.
Highly obliged.
Playing with, you know what,
I leave it to worship.
portray cannot have.
Obliged.
You may not get the order to take.
Yes,
It's already portrayed.
obliged.
Yes, Mr. Sharma.
My lord. Announcement table of FIR, my lord, at page 12 file. 7.79 kilos. Ganja has been recovered from my possession as alleged in the state FIR.
Your lordship, FSL is not there.
Last opinion was, actual report was not there. Since my lord. 13.5, my lord. Sorry, my lord. 17.7, 17P, please. Behind the part. And so far, my lord. Notice issued under section 47 of the MSS. At page my lord 21 itself.
Recovery,
My lord, as per my lord FIR, my lord, the recovery was 7.79 kilograms, which is my lord lesser than the commercial price. And so far, my lord, actual fact is concerned, my lord, the bag was not mine, my lord. So far, the CCTV.
well, that is the system.
My lord, that is the system. But while I
You are
have
arrested, you are not
Yes.
in conscious
Yes,
position.
yes, yes,
Bag is not mine.
that's true, my lord. Now, my lord, arrest memo reflects that I was arrested on 17/2025 at 10 p.m. Whereas actually I was arrested on that particular day at 1:10 a.m. And the ground of arrest is also not there in the arrest notice matter under section 47. And the region has been paid to the replica of the affair.
Raj Prem,
No, my.
not Mr. Prem. Okay, very good. And Mr. K.
Vijay Rai.
There are two.
No, man. I am appearing from Vijay Rai. I am Vijay Rai.
You are appearing for whom?
My lord, Vijay Rai. Vijay
Which page?
On item number 33, my lord. My lord, this is my lord. Bongaigaon JLPS, JLPS case.
38 of 36.
I have seen this different. FIR is at page 16.
Arrested when?
My lord, on my lord, 17/3/2025. 7.79 kilograms of ganja have been recovered. And my lord, so far,
List by order dated 21/04/2025. After that case diary of Bongaigaon JLPS case number 39 of 2025, Pharmacy Alcohol of Alcohol. Placed on 26/05/2025. Failure on the part of the concerned investigating officer to place the relevant case.
maybe in the next week, my lord. My lord, from Kylie Brown.
Along with the effort. The concerned investigating officer. JLPS Bongaigaon JLPS case number 39 of 2025.
Obliged.
May please, your lordship. Will grant you bail. Yes, 2 lakhs. Hello.
After the city was called for.
Mr. Das,
Lordship, CD is there, Lordship. Here, Lordship, we have seen that. He has appeared, but the materials are there, Lord.
After the city was called for.
It will be the. I want to point out the things, Lordship. As per CAMPA rules, Lordship, it means compensatory afforestation fund management and planning authority. Rules, Lordship, they have to, should employ or their money should be transferred to the vendors or contractors. And in this case, the petitioner has done himself withdraw the money directly from the government bank account, Lordship. Moreover, upon inspection is also done. And according to a detailed report is there, according to which, Lordship, only 30 to 35% of work is done. Moreover, another thing is there, Lordship, as per norms of plantation, there should be at least 2,500 saplings planted in 1 hectare, which is less than this Lordship criteria. Moreover, expenditure report is also there, according to the submitted by the petitioner, but their anomalies are there, Lordship, and procedural lapses are also there in the cash amount. Otherwise, his statement is recorded, Lord.
All the records to be placed before the authority, and all the work has been done as per guidance of the divisional forest officer, my lord. I give the details of that, my lord. Law work has been completed long back. But only wrong has been done by the petitioner, that some amount has been transferred to his account. But however, he spent all the money,
Some amount means kindly tell us them.
15 lakhs.
Small amount.
But he mistakenly, he admits mistakenly, but all the, that is why he was placed on the suspension also, my lord. He is on the suspension. And remember the proceeding is also has to be put that as well. But everything has been done, my lord. Every process of all the process seen by the DFO, my lord. Those are for 2022, 2023, my lord. As per the money sanction, against that money, work has been completed, my lord. I have submitted the progress report with bills, everything, and those are verified and examined by the DFO, then DFO, my lord. I consider that I will be.
But it's application, it's filed on 22, 25, petition. Second clear as plain. In water conduct, and second floor to the court. Or it's something. Yeah, no. Actually,
Interim granted on 31/7/2024.
matter relates to. Petitioner is the forest ranger in the Pakra country line. The Karimganj forest division. Karimganj forest division. The as per the FIR, dated 25/04/2023, laws before the Supreme Court of Police, Karimnagar District, Karimnagar, not Karimnagar, now state. A petitioner had illegally drawn rupees 21,05,600 in cash by way of self-check during the period from 27/03/2023 to 21/04/2024, committing financial irregularity and misappropriating huge amount of public money. From the case record, it is seen that the filtering that hectares of ANR plantation under CAMPS scheme, there 2019-20 at Panighat between Tribhum Reserve Forest of Patharkandi Range. An amount of rupees 42 lakhs sanction. To 11,000 crore. And out of that, 21 lakhs 5,600. The petitioner violating all the provisions from our rules and guidelines, withdrawn an amount of rupees 21,05,600.
This is the progress report. No, thank you.
Being rents, incest, forest of rent, forest of Patharkandi in the petition from Info Bank. My tax. And completed only 30 to 35% of the work under the state campus scheme. Misappropriating huge amount of money. The during investigation by a team of the forest officials, they found less than 2,500 samplings in the area under the campus scheme. Planted like the bail of the petitioner has been rejected by the concerned district officer. Holding that the petitioner applying and accused has already withdrawn the money by cash, misused the huge amount of the computable gain, and in fact the state it released on bail. The investigation of the case to be hampered. Considering the materials in the case that this court, that's not a fit case to grant free the state petition.
My lord, I already appear, my lord. I have been moving those about my lord. And any condition, documentary evidence are there.
You see that.
I was
pursuant to the
already placed under suspension, my lord.
Bail order granted to the petitioner, interim bail granted to the petitioner until
31/7/2024.
27/05.
31/7/2024.
31/07/2024.
I appear, as per that order.
The petitioner appeared before the concerned investigating officer of the case. But the up-to-date report of the concerned investigating officer is 06/05/2025. Of the below. And the Friday. Mr. Som will take it up on next Monday. Because many cases are left out today.
That please, your lordship.
Tell me which are the cases where you have a case there?
In 40, but in 40 lottery, it need to be up to date lottery. I was about to tell that lottery.
Okay.
41 and lordship 47, 48
40, 41, 47 and 48.
lordship,
You have the case there.
lordship. 40, 41, 47 and 48.
Okay. Before we take up any bail hearing, these matters will take up tomorrow.
48 cannot be taken up day after tomorrow. Only 48. Day after tomorrow.
48 of 40, 41 and 47 tomorrow. 48 day after.
I'm sorry, my lord, my one submission, lordship. That item number 49, lordship, and today's sublease list, lordship. The out of same FR, same forwarding report, lordship, and the court is already grant bail by the Honorable Justice Mitali Thakuya, by the lordship, and today. 49, lordship.
It is
This is
adjourned.
on 21/5.
Adjourned.
Already passed an order.
Lordship, out of same FR, that is why, lordship.
Mention has been made in the morning. It's coming up on 21st of May.
Lordship, item 14. My good. No, no,
Okay.